So Donald Trump issued his executive order on preventing online censorship. Everything should be resolved now. The battle is over. No more censorship, no more immunity under Section 230 of the Communications Decency Act.
Not so fast.
Viva Frei, Montreal litigator turned YouTuber, vlogging at you yet again from my car. You know what? Even after this Maestro and Osiris Schmendrick is over, I think I might still continue vlogging in the car. The sound in here is actually incredible. Now, for those of you who may not know, given everything else that's been going on in the world in the last week Donald Trump had something of a Twitter war with Twitter and Jack Dorsey. It wasn't a traditional back and forth Twitter war. What happened is that Donald Trump put out a tweet about California's announcement that it might be proceeding by way of mail-in ballot for the 2020 November elections. Donald Trump put out a tweet on the subject, which was really nothing more than a prediction saying that this proposal would be a disaster, it would lead to rampant voter fraud, etc., etc. Notwithstanding the fact that if most people didn't view Donald Trump's tweet as a prediction, they at the very least viewed it as a matter of opinion, Twitter decided to fact-check Donald Trump's tweet. Twitter added a little warning icon with a hyperlink to get more information on mail-in voting. Not only did Twitter think it was necessary and appropriate to fact-check Donald Trump's prediction and opinion, they thought it was necessary and appropriate to do it with the likes of CNN and Washington Post. I did a vlog on the subject the very same day Donald Trump actually signed and issued the executive order. If you haven't seen that vlog, go give it a watch. I'm going to link it right here. And for whatever the reason, that vlog was demonetized up until about 80,000 views. So where do we start? Let's just start from the very beginning. What is an executive order? Yes, I'm taking this from Wikipedia, but when it comes to politically neutral issues such as simple matter of facts, Wikipedia is still moderately useful. In the United States, a federal executive order is a directive issued by the President of the United States that manages operations of the federal government. See below for a discussion of executive orders issued by governors of each state. The legal or constitutional basis for executive orders has multiple sources. Article 2 of the United States Constitution gives the President broad executive and enforcement authority to use their discretion to determine how to enforce the law or to otherwise manage the resources and staff of the executive branch. The ability to make such orders is also based on express or implied acts of Congress that delegate to the President some degree of discretionary power. Alright, and that is as much of an overview of the definition of executive orders as we need for this vlog. This is the most important part. Like both legislative statutes and regulations promulgated by government agencies, executive orders are subject to judicial review and may be overturned if the orders lack support by statute or the Constitution. So although there is either constitutional and or congressional authority for the President to issue executive orders, they are nonetheless subject to judicial review, which means they nonetheless have to be legal. And what of Donald Trump's May 28th, 2020 executive order on preventing online censorship? Well, let's go ahead and read it. Not all of it, we're just going to go to the highlights, but let's go ahead and read it. By the authority vested in me as President by the Constitution and the laws of the United States of America, it is hereby ordered as follows. Section 1, Policy. Free speech is the bedrock of American democracy. Our founding fathers protected this sacred right with the First Amendment to the Constitution. The freedom to express and debate ideas is the foundation for all of our rights as a free people. In a country that has long cherished the freedom of expression, we cannot allow a limited number of online platforms to handpick the speech that Americans may access and convey on the internet. The practice is fundamentally un-American and anti-democratic. When large, powerful social media companies censor opinions with which they disagree, they exercise a dangerous power. They cease functioning as passive bulletin boards and ought to be viewed and treated as content creators. This executive order relates to Section 230 of the Communications Decency Act, which provided immunity to internet service providers for the content uploaded by their users. I've already done a few videos on Section 230. I'm going to create a playlist and link it right here so you can give those videos a watch when you have the time, but basically Section 230 created immunity for internet service providers for the content uploaded to those platforms by the users. In the early stages of the internet, users were uploading all sorts of illegal or defamatory content onto the platforms of internet service providers. What ended up happening is that these internet service providers started getting sued for the content that was being uploaded to their platforms by their users. And in one case, the internet service provider said, I can't be held liable for the illegal material uploaded by my users because we don't do anything to verify what is uploaded to our platform. And they in fact succeeded on that defense. A little while later, another internet service provider was sued along the same lines, except that they exercised a little bit of moderation as relates to the content that was uploaded or maintained on their platform. They raised the same defense, and paradoxically enough, they were in fact held liable because of the fact that they moderated some of the content that was uploaded to their platform. And so the fear was that this type of liability would absolutely chill the growth of the internet, because internet service providers would not necessarily want to be in that industry if they could be held liable for the illegal or defamatory content uploaded to their platforms by their users, notwithstanding their efforts to remove that defamatory or illegal content. And so the legislators came up with Section 230 of the Communications Decency Act, which provided immunity to internet service providers who made an effort to moderate their platforms to remove illegal or defamatory content. That particular section, which I'm pretty sure everybody is now familiar with, reads as follows. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. The idea being, taking the most obvious example, if I upload pirated material onto YouTube, YouTube as a platform would not be responsible for that pirated material if they had a system in place, a moderating system in place, to try and remove pirated material on YouTube. What ended up happening? We went from a world where internet service providers had immunity from illegal or defamatory content that their users uploaded if they had a system in place to try to moderate that content, to a world in which these social media behemoths, YouTube, Facebook, Twitter, not only remove the illegal content, but remove content that they say violates their terms of service, but there is no discernible pattern or rule system to determine whether or not something violates their terms of service. In other words, the internet service providers were demanding the immunity under Section 230 not only when they were moderating the site for illegal or defamatory content, but when they were moderating the site for content they didn't like. To the point where, paradoxically enough, they ended up censoring the very government that provided them immunity in the first place. Twitter, Facebook, Instagram, and YouTube wield immense, if not unprecedented, power to shape the interpretation of public events, to censor, delete, or disappear information, and to control what people see or do not see. As president, I have made clear my commitment to free and open debate on the internet. Such debate is just as important online as it is in our universities, our town halls, and our homes. It is essential to sustaining our democracy. And if I listen carefully, I think I can hear some of you screaming at your computer screens that this president is now talking about the importance of online debate, and this is the same president who had to get sued because he was blocking people on Twitter. And if I listen carefully, I think I can hear other people on the internet screaming at their computer screens Donald Trump wanted to lose that lawsuit. Now, no politicians on Twitter can block their critics.
AOC, I'm looking at you.
But I digress. Back to the executive order. Online platforms are engaging in selective censorship that is harming our national discourse. Tens of thousands of Americans have reported, among other troubling behaviors, online platforms flagging content as inappropriate, even though it does not violate any stated terms of service, making unannounced and unexplained changes to company policies that have the effect of disfavoring certain viewpoints, and deleting content and entire accounts with no warning, no rationale, and no recourse. Twitter now selectively decides to place a warning label on certain tweets in a manner that clearly reflects political bias. As has been reported, Twitter seems never to have placed such a label on another politician's tweet. As recently as last week, Representative Adam Schiff was continuing to mislead his followers by peddling the long-disproven Russian collusion hoax, and Twitter did not flag those tweets. Unsurprisingly, its officer in charge of so-called site integrity has flaunted his political bias in his own tweets. And for those of you who may not know exactly what tweets this executive order is referring to right now, I'm just going to flash a few of those tweets for you, for your general information. This section continues along in the same vein, but I think you get the idea right now. I just want to highlight one thing that I actually didn't know before reading this executive order. One United States company, for example, created a search engine for the Chinese Communist Party that would have blacklisted searches for human rights, hid data unfavorable to the Chinese Communist Party, and tracked users determined appropriate for surveillance. From what I understand, and I hope I'm not getting this wrong because there are a few things more embarrassing than being wrong on the internet, I think the executive order at this point is referring to Google's Project Dragonfly. And if you don't know what Google's Project Dragonfly was, let me just read you something from Wikipedia. The Dragonfly project was an internet search engine prototype created by Google that was designed to be compatible with China's state censorship provisions. The public learned of Dragonfly's existence in August 2018 when The Intercept leaked an internal memo written by a Google employee about the project. In December 2018, Dragonfly was reported to have effectively been shut down after a clash with members of the privacy team within Google. However, according to employees, work on Dragonfly was still continuing as of March 2019 with some 100 people still allocated to it. In July 2019, Google announced that work on Dragonfly had been terminated. The biggest search engine that determines what you see when you put in search words into the search engine, which also happens to own YouTube, was working with the Chinese government to determine what the people of China would not see when they put in search words. I don't care if you're liberal or conservative, Democrat or Republican, that should scare everybody. All right, moving along to the substance of the executive order. Section 2, Protections Against Online Censorship. It is the policy of the United States to foster clear ground rules promoting free and open debate on the internet. Prominent among the ground rules governing that debate is the immunity from liability created by Section 230C of the Communications Decency Act. It is the policy of the United States that the scope of that immunity should be clarified. The immunity should not extend beyond its text and purpose to provide protection for those who purport to provide users a forum for free and open speech, but in reality use their power over over a vital means of communication to engage in deceptive or pretextual actions, stifling free and open debate by censoring certain viewpoints. In particular, subparagraph C2 expressly addresses protections from civil liability and specifies that an interactive computer service provider may not be made liable on account of its decision in good faith to restrict access to content that it considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. It is the policy of the United States to ensure that, to the maximum extent permissible under the law, this provision is not distorted to provide liability protection for online platforms that, far from acting in good faith to remove objectionable content, instead engage in deceptive or pretextual actions, often contrary to their stated terms of service, to stifle viewpoints with which they disagree. And here is where we get into the legal meat of the executive order. To advance the policy described in subsection A of this section, all executive departments and agencies should ensure that their application of section 230C properly reflects the narrow purpose of this section and take all appropriate actions in this regard. In addition, within 60 days of the date of this order, the Secretary of Commerce, in consultation with the Attorney General and acting through the National Telecommunications and Information Administration, shall file a petition for rulemaking with the Federal Communications Commission, requesting that the FCC expeditiously propose regulations to clarify the interaction between subparagraphs C1 and C2 of section 230, in particular to clarify and determine the circumstances under which a provider of an interactive computer service that restricts access to content in a manner not specifically protected by subparagraph C2A may also not be able to claim protection under subparagraph C1, which merely states that a provider shall not be treated as a publisher or speaker for making third-party content available and does not address the provider's responsibility for its own editorial decisions. Alright, this provision is a little wordy and complicated, but the bottom line is this. Donald Trump is saying, FCC, you have 60 days to propose regulations to determine how and when these social media giants benefit from immunity under section 230 of the Communications Decency Act. The next question is going to be, does Donald Trump in fact have the authority to do this? Section 3 of the executive order relates to federal taxpayer dollars that go to fund these platforms, protecting federal taxpayer dollars from financing online platforms that restrict free speech. The head of each executive department and agency shall review its agency's federal spending on advertising and marketing paid to online platforms. Such review shall include the amount of money spent, the online platforms that receive federal dollars, and the statutory authorities available to restrict their receipt of advertising dollars. The Department of Justice shall review the viewpoint-based speech restrictions imposed by each online platform identified in the report described in subsection B of this section and assess whether any online platforms are problematic vehicles for government speech due to viewpoint discrimination, deception to consumers, or other bad practices. The bottom line takeaway here, if you are one of those entities receiving federal taxpayer dollars and the government determines your conduct to be problematic, I suspect you might have a little more difficulty getting those taxpayer dollars next year. In May of 2019, the White House launched a tech bias reporting tool to allow Americans to report incidents of online censorship. In just weeks, the White House received over 60,000 complaints of online platforms censoring or otherwise taking action against users based on their political viewpoints. The White House will submit such complaints received to the Department of Justice and the Federal Trade Commission. The FTC shall consider taking action as appropriate and consistent with applicable law to prohibit unfair or deceptive acts or practices in or affecting commerce pursuant to Section 45 of Title 15 United States Code. Such unfair or deceptive acts or practice may include practices by entities covered by Section 230 that restrict speech in ways that do not align with those entities' public representations about those practices. Under this executive order, they're going to get the Department of Justice and the FTC in to investigate deceptive acts at the federal level, but they're also going to do it at the state level. Section 5, State Review of Unfair or Deceptive Acts or Practices and Anti-Discrimination Laws. The Attorney General shall establish a working group regarding the potential enforcement of state statutes that prohibit online platforms from engaging in unfair or deceptive acts or practices. I'm going to skip over the rest of it. I'll flash a screenshot now if you want to pause it and read it for yourself, but basically they're going to be going at the federal level and the state law level to ensure that there are no deceptive acts or practices being performed by these platforms. Section 6, Legislation. The Attorney General shall develop a proposal for federal legislation that will be useful to promote the policy objectives of this order. So that is the gist of the executive order, and it has taken me so long that the weather has actually changed. The sun is out, so I have maybe 5 or 10 minutes left in this car to finish this vlog. And Trump is giving the FCC 60 days to propose regulations to determine the scope and application of the immunity provided under Section 230 of the Communications Decency Act. The legal question that I suspect will find its way to the courts is whether or not Trump has the authority to do this under this executive order. From what I understand, it is arguable whether or not the FCC has the authority to propose any regulations to clarify the scope and application of Section 230 of the Communications Decency Act. It is beyond the scope of my expertise and my pay grade, but from what I understand, the authority to enact regulations has to be provided for in the act. For example, under COPPA, the Children's Online Privacy Protection Act, it specifically empowers the Commission to make regulations. B. Regulations. In general, not later than 1 year after October 21, 1998, the Commission shall promulgate under Section 553 of Title V regulations that, under the specific terms of COPPA, the Commission is empowered to make regulations. Whereas it is arguable if the FCC benefits from the same authority under the CDA. And so the executive order, or at the very least this part of the executive order, might be unconstitutional in that the executive branch is now usurping powers that belong to the legislative branch. That is my limited understanding of the issue here. I reserve the right to be wrong, but if I am in fact wrong, please someone correct me in the comment section below, because we all get smarter with other people's mistakes. We just typically don't want to be the mistake from which other people learn, but you know, it happens sometimes. So that is the vlog just in time because it is getting hot in this car. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got merch, PayPal, Subscribestar, Patreon, etc., etc. But the best and cheapest way to support the channel is just to share it with everyone who you think might be interested in it. And more importantly than all of that, take care of yourselves, be well, stay healthy, get outside, get some exercise, fresh air, sunlight, and now you know your vlog. Peace out. Booyah!